Hey everybody, it's Mr. Ryan. I'm going to record this lecture to make sure that you guys have this information ready. If you were in class on Thursday, I'll put the timestamp of where you can skip to get the new information up on the screen or down in the description below, and you can check that out there. So today we're going to talk about the judicial system, or the best way to determine whether someone has had too much to drink, because they will absolutely slur the phrase judicious. Let's continue. All right. So, oh man, my face is too big. Can I make that smaller? I don't want it to cover. Like, I could just turn my face off, but I'm too vain for that. Anyway. We're going to talk about two different types of law, criminal law and civil law. Criminal law, if you can believe this, is when you do a crime. There's an actual statute involved where you're violating a state statute or city statute, federal statute, something. You are breaking a law, therefore you are a criminal. You're going to have a plaintiff and a defendant bring charges on an actual crime that has happened, and the defendant is the person defending. Really, really good naming scheme there. So, fantastic. It is contrasted with civil law, which is, I have this pen and I'm just going to fiddle with it the whole time. I don't know what's wrong with me. I have something wrong with my brain. Anyway, civil law, on the other hand, does not deal with actual criminal violations. It's more of whether or not wrongdoing has happened to someone. So it's going to be things like negligence or some kind of damages for something. So like if you go to the Texas Roadhouse, where you can eat the peanuts and throw them on the ground. I used to have a place called the Lone Star where you could eat peanuts, throw the peanut shells on the ground. But an old man slipped on the peanut shells and broke his spine everywhere. And so he sued the Lone Star for negligence, which is not a crime. It's not a crime to forget to do something or to be like, oh, snap, I'm sorry that I had this environment where you fell down. But you can be liable for damages if somebody falls down in your establishment. So you might remember a couple of these really famous civil law cases. Recently, E. Jean Carroll accused former President Donald Trump of sexual assault and won her case. She didn't file it in criminal court because there was not enough evidence to convict, probably, and so she did it in civil court where she won. And so former President Trump is liable for sexual assault that he committed against E. Jean Carroll then. After that lawsuit happened, Donald Trump said a bunch of very mean things about E. Jean Carroll, if you can imagine that. And so she sued him again, this time for defamation of character. And she sued him in civil court again and won again. And so Trump is liable for all sorts of damages stemming from that civil case. And I know that you guys weren't really alive or around for the O.J. Simpson trial, but when I was growing up, that was the thing that the entire country cared about. He famously, of course, was acquitted of murder because the glove did not fit, therefore you must acquit. But in civil court, he was charged with wrongful death of his wife instead of murder, and he was found guilty there and is still paying off those damages. Boop! All right. Article 3 is where you're going to find stuff about the national judiciary. We have a couple of different court systems. We have just like we have federal and state laws, we have federal and state court systems. We also have constitutional courts and special courts. We'll get into those in a second. But our court system is headed by the Supreme Court. That's why it's called the Supreme Court, because it is supreme over those. And then Congress has the ability to create inferior courts. So courts that are below the Supreme Court that will appeal cases up to the Supreme Court. And we have 3 different tiers of courts that we will go to. States are also able to have a Supreme Court and establish inferior courts, so that is a concurrent power of both states and federal government to create court systems and lower courts. And so on the federal level, we have these two different types of federal courts, constitutional and special. And we'll talk about those here in this handy-dandy graphic. Wonderful graphic here. Constitutional courts are your regular old courts. They're your district courts where you appear for a crime, courts of appeals where federal crimes will get appealed if something was wrong with the case. There is a special appeals court for the Federal Circuit called the U.S. Court of Appeals for the Federal Circuit. And the Court of International Trade. Those are all constitutional courts. They're mentioned in the Constitution. It actually has words about them there. And then we have special courts, which we don't have stuff on in the Constitution, and are for a very, very specific purpose. So they're like the appeals court for a military tribunal, or for taxes. If you are a big tax evader, you're going to go to U.S. Tax Court, which is a special court, not mentioned in the Constitution. If you have a veterans claim for a notoriously awful veteran system, then you're going to go to the U.S. Court for Veteran Appeals. And the United States owns a bunch of territory that are not states. So Puerto Rico, Guam, the Marshall Islands, the Northern Mariana Islands, American Samoa, all of those places that we own. The U.S. Virgin Islands. Did I miss any? I probably missed some. But all of those are territories that we own that are not states. They get their own special courts as well, since they're not technically part of the United States. They're just owned by us. Federal judges, for the most part, are appointed to life terms. It's very rare for a judge to be not appointed for a life term. I will send you something that says which judges are not appointed for life terms. But federal judges, as a rule, appointed for life terms. It says good behavior. They're appointed for good behavior, but that means forever until they do a crime. If they do a crime, if they do a crime, they can be impeached like all people in the federal government. They can be impeached. Same process. The House brings impeachment charges and the Senate convicts them. They can also retire or pass away. So we don't have any zombie justices. We have had but federal judges be impeached and convicted. Those are the only ones that we've had removed from office for impeachment. The president is the person who appoints federal judges. It's one of the powers of the president is to appoint judges. And they have to do so with the advice and consent of the Senate. So if someone is wildly unqualified, the Senate can reject them. Or in the case of Clarence Thomas, go ahead and put him in office. So I don't say that as a personal opinion of Clarence Thomas. He was largely considered, quote unquote, not qualified by the American Bar Association. But they voted him in anyway. So that's fun. The reason for this life tenure idea is to try and remove politics from the judgeship. As we've probably noticed from the last several times we've appointed Supreme Court justices, that is not really possible, but that's what the intent was. But what it does do is it adds consistency to law. So judges are there to interpret the meanings of our laws. And if we have different judges that are focused on election cycles, then the way that they enforce the law or interpret the law could change based on what's popular or what they want to get reelected on. So we have this life appointment to say, you don't have to worry about that. We're going to rule the same way on the same law every time. It also locks their salary in place, so we don't have to keep changing how much we pay them. So, and Congress can't, utilize that funding to coerce the judges into doing something. And I looked for life tenure on Google image search, and this metal as heck picture came up, and I thought it was just dope as heck, so I put it in there anyway. It says I'll retire soon, I swear. So, it was good stuff. Yay! All right. A word you're going to be hearing a lot is jurisdiction. You might have heard that word a whole bunch if you watch like true crime shows or anything like that, where the FBI comes in and the state troopers are like, this ain't your jurisdiction, it's my jurisdiction. And the FBI is like, it's our jurisdiction now. Jurisdiction is basically just the authority to hear something. So in a court of law, the authority to hear a case is its jurisdiction. And we have a way to separate the types of jurisdiction. If it is able to only be heard in a federal court, it is known as exclusive jurisdiction. So if there's something that is a federal crime happening, that's going to be something that has exclusive jurisdiction. Concurrent jurisdiction means it can be tried in either a federal court or a state court. So if there are disputes involving citizens of different states, you might either settle that in the state where the dispute is happening, or you would just try it in federal court. So exclusive means federal only, concurrent means federal or state. And then I think more importantly is the distinction between original and appellate jurisdiction. Where the case is first heard is where it has original jurisdiction. So that's going to generally be your lowest tier of courts, your local courts, state courts, district courts. The lowest tier of court is generally where you're going to first hear a case, and then you're probably going to appeal it up to higher levels if something went wrong. If something happened in a lower court that made the proceeding invalid, the defendant can appeal that to a higher court, and that higher court has what we call appellate jurisdiction, because they're getting appealed to. They're saying, hey, something went wrong in this case. Fix it. Fix it, fix it, fix it, fix it, fix it. So, appellate jurisdiction means you have to get a case recommended up to you from a lower court, whereas original jurisdiction is where you first hear it. The Supreme Court of the United States, or SCOTUS, as people say a whole lot in our country, has both original and appellate jurisdiction. It very rarely uses original jurisdiction and almost always uses appellate jurisdiction. But in certain instances, it can be an original jurisdiction court. We'll get to that in a second when we get to the old Supreme Court of the United States. So, exclusive concurrent, original and appellate, exclusive federal only, concurrent sharing. Words. Oh, yeah, I forgot that this is here. So if you need quick rundown reminder, exclusive only federal, concurrent is state or federal. Original is the first court to hear a case. Appellate must be appealed from a lower court. Speaking of lower courts, there are three different tiers of courts. You have your local or district courts, your local municipal courts. That's where you're going to go if you get a speeding ticket. You're going to go to your local municipal court, and they're going to say, oh, you have to go to traffic school. Fun story, in Boulder City, I got a traffic ticket for doing 1 mile an hour over the speed limit. I was doing 56 in a 55, and they gave me a ticket for it and made me go to traffic school. Ridiculous. You'll go to district court if it's a gnarlier crime than that. But stinking Boulder City, man, it's rude. Very rude of them to do that. If something was wrong with the outcome of the case, it's not necessarily that you just don't like that you were found guilty, but if something wrong happened with the case, it can get appealed. The judge made the wrong decision, there was some sort of clerical error or something like that. Then you can appeal the case, and it will go up to an appellate court. Most states have their own appellate courts. Some of them don't. I believe 40 out of 50 states have an appellate court. We did not have an appellate court until 2015. All of our appeals went straight to the state Supreme Court, and that bogged the Supreme Court down real hard. And so in 2015, we decided to create an appellate court. So you try to get that decision overturned if something was wrong with it. And then, from there, they can try to appeal again, but the U.S. Supreme Court, which has the final say on everything legal in the country, the only one that can overturn the Supreme Court is the Supreme Court later. They get to choose which cases that are appealed to them. You can look over here on the little flow chart to see where the courts flow to and from. So you have your basic courts, they go up to the appeals courts, and then up to the Supreme Court. Boop. Let's talk a little bit about federal district court. I'll move my face up here. I hope this is actually showing up as me moving my face around on the video, because I have no idea if it is or not. But federal district courts. Before we start talking about districts, I would highly suggest seeing District 9 if you are of the proper age to see it. It's rated R, so you need to be 17. But it's a fantastic movie. It's really, really similar to Franz Kafka's The Metamorphosis, which is a wonderful story about a dude waking up as a bug. It's good stuff. So, anyway, districts. There are 94 federal judicial districts in the country. And you have at least one federal district in each state. You have one in the District of Columbia. Don't mind that Logan is playing Dark Tide. I really wish that didn't show up. Whoops. And one in Puerto Rico. If you have more people in your state, you're going to have more federal districts. For example, California, the most populous state, has more federal districts than us. They have 4, we have 1. There's going to be a lot more judicial work to do in a place like California, so they need more judicial districts. District courts have original jurisdiction over the vast majority of cases heard in federal courts. There are very, very extenuating circumstances that a Supreme Court would hear that. But they hear both criminal and civil cases. So, for a criminal case, a federal district court is going to hear cases that are federal crimes. So, like serial killings, mass killings, big gnarly crimes. I'm not sure why serial killings is the first thing that came to my mind for what a federal crime would be, but that's it. That's a good one. A federal civil case is going to be different. It's going to be like trust violations, monopoly law, things like that. Like, you're probably not into video games, but Microsoft just did a merger with Activision Blizzard, which is like the biggest video game merger ever, and they had to go to federal civil court to see if that would form a monopoly on the industry. It did not, but it's still kind of ridiculous. They're bad companies anyway. Don't buy their games. Unless you like them, in which case, I guess go for it. But, so, federal criminal court is a little bit easier, but federal civil court is going to be about usually money stuff, interstate money disputes, things like that. Boop. And then we move up to the courts of appeal. There are 13 in the entire country. Each group of states is called a circuit, and each circuit gets one appellate court. So there's 11 circuits in the country. We are in the 9th Circuit, which is kind of notorious. A lot of people get really grumpy about the 9th Circuit Court of Appeals. It tends to be really liberal, and a lot of people get mad at that sometimes. And they hear appeals from federal cases. There are 2 appellate courts that are not on the state circuit. There is the Federal Circuit Court of Appeals, and the state circuit courts of appeals hear appeals from state courts. Federal Circuit Courts of Appeals hear appeals from federal cases. And then Washington, D.C. has an appeals court that is for things like Congress, and when you have to appeal decisions made by the federal bureaucracy. So let's say that they needed to investigate whether or not the CIA was able to investigate somebody or not. A court of appeal would be able to see that at the District of Columbia Court of Appeal. It wouldn't go to a state court of appeal. However, if there was a federal crime that happened in Nevada and it got appealed, it would go to the Ninth Circuit Appellate Court. Hopefully, those words made sense. Fingers crossed. If not, ask me questions. Thanks. The reason that it says incredibly important on the District of Columbia is because that's how decisions made by the executive branch or by Congress get overturned. So if Congress or the executive branch do something illegal, the D.C. appellate court is the one that's going to hear that case. So it's super important for that reason. Boop. And then we have special courts. Special courts are special. They have a very specialized reason for existing. They have various things that they do that aren't mentioned in the Constitution, but there's got to be a reason for them, and so it's usually really nicely named, so you know exactly what's going on in the court. For example, U.S. Tax Court is where they deal with tax cases. So that's pretty self-explanatory. So the U.S. Court of Appeals for the Armed Forces, if you go to a military tribunal and you have an appeal, that's where your appellate case is going to go to. The U.S. Court of Federal Claims is for claims made by the federal government. So money stuff that is happening on the federal level. International trade, one tier higher than that, is going to be like our trade negotiations with Canada and Mexico for NAFTA, or the renegotiated NAFTA that happened under President Trump. If you are unfamiliar with NAFTA, I would check it out. It is the North American Free Trade Agreement. Big trade conglomerate between Canada, United States, and Mexico. And then the local courts of the territories that we own are also special courts. This is a Saturday Night Live reference from like the late 80s, early 90s. You were not born. I was hardly born. So, that's Church Lady. She always says, well, isn't that special? Among other things. So let's talk about the Supreme Court. The Supreme Court is the court that's at the top. That is the highest court in the nation. As I mentioned earlier, they have both appellate and original jurisdiction. Most of the time, it's appellate jurisdiction. I'll get into when it's original right now. It's when it's interstate disputes, basically. If Nevada sues Utah, that's when the Supreme Court is going to have original jurisdiction over a case. Very rarely do they have original jurisdiction. And if someone claims that they do, they'll usually kick that back down to a lower court. There are currently 9 members on the Supreme Court. That number has historically changed and can still change. Congress determines the number of justices that are sitting on the Supreme Court at any time. They can pass a judiciary act. However, we've kind of been stalemated at 9 because it's such a huge political debacle when someone suggests adding justices to the Supreme Court, because it's always really heavily politicized. You might remember from U.S. history when Franklin Delano Roosevelt tried to add members to the court because his New Deal policies kept being declared unconstitutional. So he said, hey, why don't we just add some more justices that I would appoint that would stop making my stuff unconstitutional. And so people accused him of being a labor-appeasing, Supreme Court-packing Bolshevik. But that's neither here nor there. We've also been talking about it recently because of the immense sway that 9 people have over the legal system in the United States. A lot of people think that we should have more. The Supreme Court hears very few cases, and so a lot of people think that we should do more justices to make sure that we hear more cases, because they're often hella important. We'll go through the roll call here. In the lower left, we have Sonia Sotomayor. To her left is Clarence Thomas, the guy who falls asleep during proceedings and reads newspapers and stuff. In the middle, this is the Chief Justice of the Supreme Court. He presides over the whole court, and it's his job to preside over impeachment trials unless he doesn't feel like it, which is a thing that actually just happened in the last impeachment trial. So that's John Roberts, Chief Justice John Roberts. To his left, we have Samuel Alito. I don't know why I'm saying to his left instead of to the right, because that's needlessly confusing. So this one right here is Sam Alito. To the right is Elena Kagan. This is the newest justice to the Supreme Court, Ketanji Jackson Brown. I got that right? I always mix up. No, it's Brown Jackson. I always mix up the middle and last names, and I don't know why. Ketanji Brown Jackson is her name. To the left there is Brett Kavanaugh. Then to the left is Neil Gorsuch. Then to the left is Amy Coney Barrett. The ones in the back are all very new. Very new justices. The big thing that the Supreme Court does is they interpret constitutionality with a power that's called judicial review. So they determine whether or not something that happens in the country happens according to the Constitution. They didn't always have this power. There was a court case where they determined that they had the power. So basically, they gave themselves the power in this court case called Marbury versus Madison. Really, really, really famous court case. Most social studies classes talk about it. In fact, let's talk about it. In the election of 1800, if you've seen the Hamilton musical, you probably know about this election. It's between John Adams, Thomas Jefferson, and Aaron Burr. John Adams was wildly unpopular, and so he wasn't winning anything. And so, in the last days of his presidency, he appointed a bunch of judges to the federal judgeship to try and cement his legacy. We call them the midnight judge appointments because, as the rumor goes, he was up until midnight appointing justices until he could no longer legally do so. William Marbury was one of the justices that was appointed. Thomas Jefferson, who won the election and had Aaron Burr as his vice president, did not like him, did not like William Marbury, and so said, "Hey, what's up? You're not a judge." And William Marbury sued, saying, "Hey, the Judiciary Act of 1789 says that I am a judge, so there." And said that the Supreme Court had to deal with it because it was supposed to have original jurisdiction in cases like that. The majority opinion, that is the opinion that matters. There are a couple of different opinions. The other ones don't matter. We only care about who wins. The majority opinion was unanimous. 5 justices voted in favor of it. They decided that they were overturning the Judiciary Act of 1789 and furthermore determined that appointed judges with commission could sue if they weren't given the job. So Thomas Jefferson was supposed to have given him the job. But they said, hey, the Judiciary Act of 1789 isn't constitutional because it says we have original jurisdiction, but we don't. And so they determined that on their own. Oh, snap, Kyle's home. Alright, I gotta shut this door. There. Maybe I should clean. There. Go. Yeah, good job, me. Anyway. Oh, man. That was hard. Marbury versus Madison. They gave themselves immense power. Judicial review applies to basically everything that the federal government can do. I'll give you some examples of lots of those. So, the Supreme Court can review acts of Congress. In fact, I think that's mostly what they do, is review acts of Congress. For example, in 2012, oh, God. House Republicans tried to get rid of the Affordable Care Act, Obamacare, and the Supreme Court upheld it, saying that it was constitutional. They also can review state actions, usually on the basis of the Supremacy Clause in the Constitution. For example, there was a court case after Obergefell versus Hodges in 2015. That was the case that legalized same-sex marriage. Arkansas tried to deny same-sex couples from taking each other's last names or whoever's spouse's name they wanted to take. Arkansas said they couldn't do it. Pavin versus Smith ruled that Arkansas cannot do that. If there's an action taken by a federal agency, the Supreme Court can review that. It usually tries to review what language is meant by Congress. So federal agencies actually execute the law. They're supposed to enforce the law as they think Congress has written it. And so they will try to clarify those things. But it's kind of funny because sometimes they'll make it even more confusing. For example, in Brown versus the Board of Education 2, which was supposed to clarify the decision in Brown versus the Board of Education 1, they said, hey, you're supposed to do this with all deliberate speed, which that's like, give a timetable, make it exact. It's crazy. Anyway, the president can do stuff, and the Supreme Court can determine whether or not that stuff is constitutional. So, for example, in 2006, the Supreme Court intervened when we were unconstitutionally waterboarding prisoners of war in Guantanamo Bay. We were doing that a whole lot. Both Donald Rumsfeld and Dick Cheney were very big fans of torture. In 2018, more recently, you might remember when former President Trump banned travel to several Muslim-majority countries. People were colloquially calling it the Muslim ban. And Hawaii sued the president, saying that he doesn't have the ability to do that. And the Supreme Court upheld the president's ability to do that. When the Supreme Court makes a decision like that, it becomes precedent, which means it's a decision that they base future decisions off of. And it becomes what we call common law. So, for example, tort law, which is laws that decide whether or not someone has caused harm to another, they're decided by precedent instead of like a specific statute. So they're like, in cases like this, where someone has caused these kinds of damages, we're going to see how we've ruled before and rule the same way. Let's talk about some fun Latin terms. The way that the Supreme Court gets its cases is by issuing what we call a writ of certiorari. That's a fun word to say. I like it a whole lot. That's why it says it's my favorite judicial term, because it is. A writ of certiorari. So a petitioner, the person bringing the case, will petition the Supreme Courts for a writ of certiorari, and a respondent, the person defending, will tell the appeals court why the lower court's decision should stand. Only 4 Supreme Court justices are necessary for issuing a writ of certiorari. Because it's only 4 people, that's called the rule of 4. So, in order to hear a case, they issue one of these writs of certiorari. It's basically a piece of paper saying, yeah, we'll hear that case. That's the whole thing. So, I know I'm kind of beating a dead horse here, but the Supreme Court does sometimes have original jurisdiction in interstate disputes. Only in interstate disputes, though. So, big thing. The judicial session just started, actually. They go from October to either late June, early July. If you want to know what cases are on the docket for the Supreme Court to hear, they are publicly available. You can go to their website and it shows you the entire calendar of when they will hear stuff, what cases they will hear. Totally public knowledge. In order to be considered by the Supreme Court, you actually have to have standing. Like, there needs to be a reason for someone to hear it. Like, some money needs to have exchanged hands, or some kind of damages need to have taken place. It's not just like a I don't like you, so I'm going to sue you kind of thing. And the case also can't be moot, where it means it's too late to actually affect anything. But that, like if you ever heard the term a moot point, it means it doesn't really matter because the time for it to matter has already passed. But the timing for a case to be considered moot is determined by the court. They get to determine whether or not it's too late for it to matter. For example, in Roe versus Wade, Jane Roe, the woman in question considering the abortion, the Supreme Court case took place long after she had already had the child. And so the respondents argued that the case was already moot because she had a kid, and so they're not going to abort a living person. So the court decided, though, that the issue itself was not moot and would come up in the future, and so they decided to hear it. That's Justice Brett Kavanaugh there, defending his love of beer in the Senate confirmation hearings for his appointment because he was accused of rape. He is one of two of the Supreme Court justices that are currently sitting that have been accused of rape. Him and Clarence Thomas. If you want to know how a court case is named, the first name is the petitioner, the person bringing the case to the court, followed by the word versus, meaning against, and then the respondent is second, and then the year the case was heard. Always put court cases in italics. The year is not in italics. So if you're ever talking about a court case in a current event assignment or a discussion board, italicize the petitioner and respondent, but not the year. This is just a graphic representation of what we just said. But I will add that once a case gets to the Supreme Court, they can do a couple of different things. They can look at the case and say, oh no, whatever the lower court said, that's fine. They might send the case back to a lower court and say, hey, reconsider these things. Or they'll choose to take the case. So they usually just let the ruling stand. They rarely take cases given the number of cases that they get. There's two different ways of interpreting the Constitution for I think we've actually caught up to where we were in class. So, hey, if you remember where we were in class, this is where we are now. A couple of different ways of interpreting the Constitution. The Constitution was supposed to be called a living document, something that changes over time as society does. And so justices have a different way of interpreting that based on their personal philosophy. The first type of interpretation is called strict or narrow constructionist. That means you take the words of the Constitution super literally as it was written, in the original text it was written. You don't change anything. Like, everything's the same as in 1789. Obviously. This is usually seen as the more conservative ideology for interpretation of the Constitution, whereas the more liberal idea is either known as loose or liberal constructionist, which sees the Constitution as a changing document that changes given the context of what the country is currently seeing. And so it might rule differently in a later year based on changes that have happened in society. And I made a really good Looney Tunes joke right there. You guys remember Looney Tunes? It's Wile E. Coyote. It's good stuff. I'm a genius. So here's an example. Let's say that it's 1905 and life is a nightmare. Like, more so than it is now. It's a horrible nightmare. All of you would be working. Actually, all of you would probably be retired from working in a horrifying coal mine or textile factory, something like that. You'll work 80-hour weeks. You don't get any money. It's awful. So New York decides to pass a law that says that workers are forbidden from working more than 60 hours a week and 10 hours per day. Someone that wanted the freedom to sign a contract allowing him to work more than that sues the government. He's saying, hey, I want to work more than 60 hours a week. Sues the government. It gets appealed all the way up to the Supreme Court. The strict interpretation of the Constitution would strike down the New York law as unconstitutional because it interferes with the due process clause. It says, hey, you got to have due process, which is just the process for doing stuff. It says, hey, you don't have due process. You gotta make sure the workers are okay with this kind of thing. Whereas a loose interpretation would uphold the law as constitutional because the 10th Amendment allows states to have reserved powers, and societal changes on worker safety would be different. For those of you who are wondering which one actually won, the strict interpretation won in this case. The link to the case is there in the paragraph. This is a fancy Latin term that you're going to need to know. This first part is a lot more important than this second part. So the types of precedent don't really matter as much as the name, the fancy Latin name of using precedent. So most Supreme Court decisions are based on stare decisis, which is Latin for let the decision stand. You're supposed to rule off of what the previous rulings were. So you're supposed to base it off old stuff. That's the important part. To expound on that, there are two different types of precedent that get established. So there's binding precedent, which means lower courts are required to rule in a similar fashion to an established decision. So if the Supreme Court says something and establishes a binding precedent, lower courts, regardless of what the judge thinks about the circumstance, has to rule a certain way. Then it can try to get appealed up to a higher court because of differences, or it just dies there. And then there's persuasive precedent, which basically looks at the precedents in similar situations in other states and tries to rule somewhat similarly, or they look at different circumstances to see what's different based on stuff that's around. So binding is just like an edict from a higher court that says you have to rule this way. Persuasive is when there's not really a proper answer to that question, and so they look around to be like, what have other courts done that can influence my decision on how to rule now? That's Judge Judy. That's Judge Dredd. Sometimes the Supreme Court just ignores stare decisis because there might be a precedent that they think is wrong. Usually this is intended to protect the rights of the minority that have been broken by that of the majority. A lot of the time that happens in racial conflicts in the United States. So, for example, we had Plessy versus Ferguson, which decided the separate but equal doctrine. Black people are allowed to have separate facilities as long as they're equal, with a very big asterisk after the equal. But the judges 50 years later in Brown versus the Board of Education said that that separation is inherently unequal. And so they overturn Plessy versus Ferguson to change it because that precedent from before was bad. A lot of people see this as bad. They call it judicial activism or legislating from the bench because if you strike down laws as unconstitutional, that basically creates new common law. And so 9 people really get to decide the law for the entire country. And so a lot of people frown on judicial activism. Those who practice the opposite are known as judicial restraint. So if you uphold precedent because it's not the judicial branch's job to determine or create policy, you're practicing judicial restraint. If you issue a judicial mandate or a judge-made mandate, that's an official court order to do something. So a really good example of this is the Miranda warning from Miranda versus Arizona. You've probably heard the Miranda warning before. They say what you're being arrested for. You're under arrest for the murder of O.J. Simpson. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, one will be provided for you. Do you understand these rights as I have read them to you? That's the whole Miranda warning. Judges say, when you arrest someone, you have to say all of these to make sure that the prisoners are aware of the rights of the accused that are in the Constitution. That's a judge-made or judicial mandate. How a Supreme Court proceeding works is each team of attorneys will provide a brief to the justices explaining their case, why they think that their side is correct. They will cite lots of different precedent and lots of different laws. They say, hey, the court should rule in this way. They give it to the justices for them to consider before the case. After that, there's oral arguments where the lawyers basically give a speech that gets interrupted constantly. The lawyers will try to state their case, and the justices will just pepper them relentlessly with questions about precedent and things like that. They'll interrupt them. They'll be incredibly rude. It's actually really fascinating to watch. So if you ever want to hear some Supreme Court proceedings, they're pretty cool. So each side will present their case before the justices. It will go under scrutiny verbally from every justice except Clarence Thomas, because he'll be asleep. I don't mean to harp so much on Clarence Thomas, but these are things that he does. Like, he falls asleep. Like, the other justices are working, and he goes to sleep or reads. It's really weird. So, after that, everybody wakes up Clarence Thomas, and they go back to confer on their decision. They talk to each other as to how they're thinking they're going to rule. Every justice can rule how they want to, but they talk about the precedent and things like that. And then they go to write their opinions. The majority opinion is what the court has decided. That's what will be put in place and what will go into effect. And they can write their opinions. I think I have. Oh, yeah, here we go. Here are the different types of opinions. One of the justices will write the majority opinion for the case. So if they vote 5-4 in favor of something, the 5 dudes or ladies, the 5 people that made the decision will explain why they ruled that way. Sometimes justices agree with the decision, like they agree that the thing should be upheld or struck down, but for a different reason than the majority opinion. So they might issue what's called a concurring opinion. They're like, I agree with that, but for a different reason. Dissenting opinions are justices explaining why they disagreed with the majority opinion and usually making an appeal for why things should change. And there's also what's called a per curiam decision, where instead of hearing a bunch of different opinions from individual justices, they'll just issue kind of a, hey, the court says this, and give like the court's opinion on something without individually labeling justices. This is probably going to be in like a unanimous decision or something like that, where they don't feel the need to go into the nuance of the law or different interpretations of precedent. It's kind of just like, oh yeah, no, we hit the we all said this, basically, is a per curiam decision. All right. The judicial branch, of course, interacts with the other 2 branches of government. And so let's talk about a couple of the ways that they do that. They interact with the executive branch because presidents appoint federal judges. That's how they get their jobs, including Supreme Court justices. But in turn, the courts preside over either disputes or decisions made by federal agencies in the executive branch. So if the FCC does something, the Supreme Court interacts with the executive branch by determining whether or not what the FCC did was legal. The FCC is the Federal Communications Commission. They're the people that censor the songs on the radio. The radio was this thing that people used to listen to hear music. So if you heard a song that had the F word in it, they would cut that out. And so it would be funny to listen to something like Eminem, because he'd be like, "Hey!" And then the song would be over. So, good stuff. They interact with the legislative branch by specifically with the Senate on this one. Advice and consent is a really, really big thing. So the Senate gets to approve whether or not federal judges take the bench. That has become a really contentious area for a lot of stuff, mostly because of what happened with current Attorney General Merrick Garland. When President Obama was leaving office, it's known as being a lame duck president, when you've served both your terms and you're just kind of waiting for the next election to happen. Obama was a lame duck president, and one of the justices that was currently on the was at the time on the Supreme Court, Antonin Scalia, passed away. And so he nominated Merrick Garland to be a Supreme Court justice. And the Senate just didn't vote on him for a couple hundred days. How many days was it? Merrick Garland days without vote. How many days? Just tell me how many days. I'll cut this part out. I'm not going to cut this part out. 293 days is how long the Senate just didn't confirm him. So, for those of you who are good at hearing numbers, that's almost a year that they just sat not confirming a Supreme Court justice. So, that caused a lot of hullabaloo because the Republicans said that it was because they thought that the new president should decide the new Supreme Court justice, but then they waited a really, really long time. And then they said, and then the same thing happened, but with the sides flipped. And they said the opposite, and everybody got mad at each other, and it was awful. Neil Gorsuch got confirmed like almost immediately, even though he was in the same kind of situation. Brett Kavanaugh had the whole rape investigation where he was investigated for rape. And so it's a lot more politicized and crazy than it really has been in the past. We have such greater communication abilities than we used to have that it's hard not to know that something that major on the federal scale is happening. So, Congress will issue the litmus test application to federal judges to kind of see where their ideology lies. If you saw the confirmation for any of the recent Supreme Court justices, you probably saw them being asked about how they would rule on certain ideological cases, and that's the litmus test there. They try and see whether or not they would be impartial or if they have like really strong opinions on certain things. There's also what we call senatorial courtesy. It's not expected that the president is going to know every judge in the country to nominate them to the Supreme Court or their federal judgeship. And so senators have the job of recommending their local judges to be considered by the executive branch. So that's kind of a all three branches sort of meet up. The bureaucracy is what makes the government work underneath the executive branch, and they have some very significant interactions with the judicial branch, especially the Department of Justice, which administers the laws that are based on, law. So the Department of Justice works very closely with the Supreme Court. The Supreme Court determines whether or not things that the Department of Justice does are constitutional. There's a big argument right now whether or not what the FBI has done with former presidents has been constitutional. And there's also someone in the bureaucracy named the Solicitor General. And the Solicitor General basically solicits the public for their opinions on court cases. People can interact with the court by suggesting how the court should rule in a certain situation. And they do that by filing what's called an amicus curiae brief. And so people will send these suggestions to the Solicitor General, and the Solicitor General will forward them to the Supreme Court saying, hey, the people think that you should rule this way. So as you can imagine, on a lot of the more recent, the 2022 Supreme Court session was rife with a lot of amicus curiae briefs. But that's one way that you, as a citizen, can interact with the judicial branches by filing an amicus curiae brief saying, hey, we think that you should rule this way. And interest groups also have a pretty big sway on what happens with justices, especially the American Bar Association, which is a group of people who are lawyers and judges, and they rank the ability of judges and send that information to Congress to determine whether or not they should be appointed. There's 3 different titles that the American Bar Association will grant to a judge: well qualified, qualified, and not qualified. Every justice on the Supreme Court has a well qualified rating, except Clarence Thomas, who had a split between qualified and not qualified. So no one said he was well qualified. Got the job anyway. So he was also in the middle of a rape trial. Clarence Thomas. So, how can we stop the Supreme Court? Checks on the Supreme Court. The best way, since the court bases all of their decisions on the Constitution, the best way is to change the Constitution. If you make the Constitution say what they're ruling on, then they can't say otherwise. However, getting a constitutional amendment passed is incredibly rare. And so they have to listen to the Constitution. If you change it, they have to listen to that. If the Supreme Court determines that a law is unconstitutional, Congress can pass a new law. So they just have to make sure that they don't include the things that the Supreme Court said were unconstitutional. So they might tweak the law in a certain way. And in order for that to change, it has to go through the legal system entirely again. And that takes a really, really long time. So Congress has the ability to check the Supreme Court by just passing more laws. Granted, passing laws is also very hard, but still. If the Supreme Court does a crime, they can be impeached. Granted, it's incredibly rare for impeachment convictions to happen. We've only had 8 in the entire history of our country. And so it's really difficult to do so. You need a 2/3 supermajority. That's 66% of the vote, which in the Senate is 66 people. So I think you need 67, actually. The appointment and confirmation process is a nice check because the executive branch can't just willy-nilly put anybody onto the Supreme Court that isn't qualified. President George W. Bush tried that in the 2000s by nominating a lady named Harriet Miers, who was not a judge, like never was a judge at all. And everybody on the Senate was like, so you're trying to make this person the highest judge in the land when they've never been a judge before, ever. And George W. Bush said, that's exactly right. They didn't approve her. So that happened. And the executive branch is in charge of enforcing the law. So if the Supreme Court says, like, hey, do this, and the president says no, then the Supreme Court doesn't really have an enforcement mechanism to make them do that. Probably the best example of this is when the Supreme Court determined the Indian Removal Act during the Andrew Jackson administration back in the early 1800s. The Supreme Court said that the Trail of Tears was very unconstitutional, and Andrew Jackson is rumored to have said, the Chief Justice has made his decision, now let him enforce it. And then went on with the Indian removal, regardless of what the court said. So, I think Hamilton wrote the Federalist paper that says that the Supreme Court is the weakest of the three branches because it doesn't have the power of either the purse or the sword, which is the enforcement power. So they can't enforce the decisions that they say. They have to rely on the other two branches in order to do that. And so that's what most consider a check on the Supreme Court. We had a very eventful 2022 judicial session. As you were probably aware from being alive, Roe versus Wade was overturned by Dobbs versus Jackson Women's Health Organization, which did a couple of things. It's a term, we'll talk about what the substantive right of privacy, the substantive due process is. We'll talk about what that is later. But basically, it says we don't have the right to privacy. And it also removed the federal restriction on abortion bans. So basically, it devolved the responsibility of abortion law to the states. Doesn't mean that it made abortions illegal everywhere. It means it left it up to the states to decide. And then both Engel versus Vitale and Lemon versus Kurtzman were overturned by Kennedy versus the Bremerton School District, which basically got rid of what we call the Lemon test, to determine whether or not government speech is secular. So basically, Engel versus Vitale and Lemon versus Kurtzman decided whether or not teachers can proselytize in class, basically push a religion. They instituted this legal test called the Lemon test, which basically said, does what is being said, does that have a secular purpose, like just a non-religious educational purpose for what's happening? Does it have excessive government entanglement with religion? Things like that. That has since been overturned, and teachers are kind of free to do all sorts of stuff with religion. It's a case that's about prayer on football fields, and it's an interesting one. Check it out. So that is the stuff about the judicial system. Yay! We got through it. It only took an hour. Fantastic. Now I just have to edit that video and upload that video and tell you that the video exists. Anyway, I'll see you on Thursday. Have a good day. Bye!